This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and good morning and welcome to the January 2022 Knoxville docket of the Tennessee Supreme Court. We appreciate the attorneys joining us by Zoom this morning. I know that's not always easy, and we appreciate your hard work in doing that. Also, welcome to the individuals who are watching us by live stream on the court's YouTube channel. We welcome all of you. In just a moment, Mr. Hibner will call the first case. Each side will have 30 minutes. If the appellant wishes to reserve time for rebuttal, please do so when you begin your argument. Mr. Hibner, you may call the case.
State of Tennessee versus Tyler Ward Enix.
May it please the court, my name is Jonathan Harwell. I'm a member of the Knoxville Bar. I'm here on behalf of the defendant appellant Tyler Enix. I've requested to reserve 5 minutes of my time for rebuttal.
You may proceed.
I would like to approach the argument in a few stages. First, to discuss as sort of foundation for our issues, what the holding of the 2017 decision in State versus Hawkins was. Second, to discuss essentially the policy reasons as the court considers what the rule in the situation should be going forward. And thirdly, I do want to discuss the specifics of Mr. Enix's case in terms of the errors that were made, or the improper arguments that were made in closing, and how those impacted on the specific circumstances of that case. As I said, the first thing I want to talk about is State versus Hawkins, because that was the rule certainly in place at the time of this trial. There has been dispute between the parties. In this case, there has been dispute before the Court of Criminal Appeals as to what the holding of Hawkins was. I believe, and have set out in our brief, there's really only one fair way to read Hawkins. Hawkins dealt with a situation. There were four on appeal. There was four claimed improper arguments. There was a use of the word rape, calling the defendant mean, use of a demonstrative aid, a saw, I think, and there was a claim the defendant never shed a tear for the victim. So four issues in the appellate court. This court noted there had been no contemporaneous objection to any of the four at the trial during the closing argument. There was a pretrial ruling about the word rape. This court noted that because, well, two of the issues, the word rape and calling the defendant mean, were included in the motion for new trial. The other two issues were not included in the motion for new trial. This court noted that because of that, the trial court had an opportunity to discuss those two issues in the motion for new trial, but no opportunity to address the two issues that had not been included. And then in the analysis section, the court said fairly directly that the two issues that were not included in the motion for new trial, plain error was being applied. It then said, although the defendant did not contemporaneously object to any of the instances of improper argument, we will apply plenary review rather than plain error review to the two alleged instances of improper prosecutorial argument raised in the motion for new trial.
Mr. Harwell, this is Justice Page. Let me talk to you about the Hawkins case just a moment. I mean, the first case, the state conceded that the word rape should not have been used by the prosecutor in closing argument. That was the subject of a pretrial motion. And doesn't that put it in a separate category? Then
yes,
and
I agree with that.
So I guess in looking at your brief and everything, you've got a 46-page opinion on a death penalty case and a long appendix. You pulled out one sentence from that case and are arguing that it changed the standard review when there was no contemporaneous objection. Is that a fair statement?
I don't agree with the one sentence, because I think these concepts appear several times in the opinion, in that the court notes
But there's only one sentence when it stated that there will be plenary review applied to those first two issues, correct?
there is that. There is also a sentence stating the converse. So saying, we review the remaining 2 instances of allegedly improper argument, which the defendant did not cite as error in his motion for a new trial under the plain doctrine.
But there are no citations to any cases at that point either, correct? On either of those points.
I think that's accurate.
Mr. Harwell, I think you're very wise to seize on that one sentence and possibly 2 sentences out of Hawkins. But the court typically doesn't make a large, significant change in the law in one sentence and without citing any authority or doing any analysis. And the state says, well, we didn't object. There was a waiver. Now, the court didn't explain that. And I was on the court then, and I'm having a little buyer's remorse about this sentence in Hawkins and wishing maybe I'd been a little more alert when I signed off on that opinion, because this really does make a pretty dramatic change in the law. And do you agree that's not typically how we make those type of changes? Because aren't we here, if we agree with this, aren't we carving out a huge exception for making objections during closing arguments?
I think it certainly is approaching this issue differently than a lot of issues, and I plan to talk about the reasons for that. If I could go back to just to one thing, I think I don't accept that there is no analysis in the court's opinion, because what the court does do in discussing the facts and in interweaving around these 2 sentences that I've highlighted because they seem quite clear to me, it talks about the significance of the motion for new trial stage. It talks about how the issues that were preserved in the motion for a new trial were presented to the trial judge. The trial judge had a chance to review them, had a chance to talk about them, had a chance to make findings about them. The court also talks about the issues that were not presented to the trial judge in the motion for a new trial because the court didn't have any opportunity to address those. So I think that is the analysis that supports the conclusion that is stated that this is the dispositive factor for review. As to your second question, I think the court certainly can choose to be very explicit in overruling prior authority. I'm not aware of any authority claiming that the court has to be. When the court issues a ruling, the holding of that becomes good law, whether it is a 15-page opinion or a 1-paragraph opinion. And the other thing I would say is this was certainly an exception or application of the law that had not been spelled out in detail before. But I'm not sure this precise argument had ever been made to the court. And looking back at the cases that had been cited by the state here, does not seem to me that anyone had ever argued that inclusion of a improper prosecutorial argument issue in a new trial motion was enough to preserve the issue for appeal. So there is no precisely on point case prior to this that Hawkins was directly overruling, which I think could explain why the court might not choose to make the overruling explicit.
And I think that's the importance of this case, is to bring this to the forefront and make a definitive ruling. Do you think it matters that Hawkins was a death penalty case? And defendants often argue death is different and you really get the benefit of the doubt in review. Do you think death is different theory sort of played into Hawkins and why this was reviewed under plenary, under a broader review standard?
I didn't see anything in the opinion that would suggest that. I don't know, particularly if the error is a trial, a guilt phase error instead of a sentencing phase error. I don't know why that difference would affect the outcome.
Thank you.
Mr. Harwell, it's Justice Bivens. To follow up on Justice Lee's original point about the lack of significant analysis there. I mean, I understand what you're saying is that there are things there, but you would agree, would you not, that normally when this court decides a significant issue that will impact many cases down the line in a way in which is in essence a change of the law. This court normally goes into a very detailed analysis, looking at our cases, oftentimes looking at cases from other states, and sometimes even from the federal courts. And that didn't happen in Hawkins, right?
There's no indication in the opinion that all of those things happened. Yes, I agree. But my response is that that's simply not necessary. That was the holding of Hawkins. That's how the court reached its decision in Hawkins. Once it was issued, that became the governing law in Tennessee. This court certainly has the ability to now change that law. But I think there is a burden now on the state, or at least a burden on the court under principles of stare decisis. There needs to be a strong reason to change a holding like that.
Well, let me follow up, Mr. Hart. This is Justice Kirby. Let me follow up, if I could, on Justice Bivens' question. If we were to analyze cases from other jurisdictions, would we find other jurisdictions make the distinction that you are advocating, essentially saying that in closing argument, defense counsel need never make a contemporaneous objection? Would we find what would we find in surveying other jurisdictions on that?
I think I haven't cited a case that is exactly on point from another jurisdiction. I did cite the Sixth Circuit authority pointing out that in some circumstances, depending on the kind of error, the kind of impropriety, you don't even consider whether there was a contemporaneous objection.
That's the nature of plain error review, right? If it's a really egregious violation, then it will be fully subject to analysis under plain error. Let me explore the ramifications of what you are advocating. Wouldn't that change actually result in a situation where, in closing argument, defense counsel would have not only be not obligated to object contemporaneously, but would in fact be incentivized not to, no matter how egregious the prosecutorial misconduct? He would be able to basically sit back, see how the trial went for his client, and not bring it to the trial judge's attention or ask the trial judge to issue any curative instruction to the jury. Wouldn't that in fact be the result of what you're advocating?
I want to go back just a second and then return to that question. But I wanted to say, with respect to other jurisdictions, there's a very significant difference. Tennessee is unusual in having the motion for new trial stage, where you can file a motion for new trial in federal court, but you don't have to. You can go straight to appeal. Tennessee has a stage. Obviously, defense attorneys think that stage exists solely to force us to waive issues. But there's actually a benefit to having a motion for new trial stage. It allows us to take an issue to the trial judge, to have a trial judge rule on that. And so that's why other jurisdictions don't have this kind of Hawkins rule, because they go
states as well.
I'm not aware of other states that have the same requirement. There may be some that have the same new trial motion stage. To answer your question about incentives, the state has made that argument. I have heard that argument. I think that is a hypothetical set of incentives that does not exist. I do not think there are any trial defense attorneys who hear an argument that is so powerful and so detrimental to their client and so improper, and they sit back and think, well, what I really, this is really hitting us where it hurts. But maybe what we should do is not say anything now, and 2 years from now, I can get the CCA to reverse this conviction and let my client out of prison where he's been for 2 years. That is an incentive and a decision that just simply does not happen.
Mr. Harwell, to follow up on Justice Kirby's question, I mean, if we put ourselves in the position of the trial judge, don't contemporaneous objections give that judge an opportunity to instruct the jury on what happened, rule on the objection, and then move the trial along that way. If we don't have any objections, you're going to put the trial judge in a position of having to referee a lot more than he or she would have under our current system, right?
I say two things. One, that doesn't sound like a bad outcome to me, to have the trial judge more involved in providing a fair trial. The second is, this is thinking about my argument. I'm really making a practical argument that is based on the way that trials really happen in our state. And the way that trials really happen in our state is when a defense attorney actually objects to an improper argument. Right now, what a trial judge says is, jury, your memory controls, or general, move along, or turns to the jury and say, remind you, arguments of counsel are not evidence. It accomplishes virtually nothing in the vast majority of the times of objecting. And that's the practical reality.
Mr. Harwell, the judge could also say, motion granted, jurors do ignore that last comment. That was improper. So there can be good instructions given to a jury that will dispel the results of improper argument.
There can be instructions that could be given. I don't think those are given all that often. And I don't think even that kind of instruction actually dispels the problem. If an improper argument is made and defense counsel jumps up and complains and the judge says, disregard that, again, as a practical matter, do we really believe that jurors forget that argument ever happened?
Well, isn't what you're outlining, Mr. Harwell, basically all the strategic calculations that defense counsel have to make? I mean, that happens throughout the trial. Are we to do away with contemporaneous objections throughout the trial because, oh, the witness may be sympathetic, or there may be other reasons why a defense counsel would not object to some conduct by the, I mean, you're just talking strategy and the legal culture. You're not talking any actual impediments to contemporaneous objections. You're just talking about the strategic calculation that defense counsel have to make every minute of every trial.
I think there's two differences between closing argument stage and the presentation of evidence and the rest of the trial. One is closing argument really is looked at by jurors as a time to really hear the exact theory. They're focused in on the argument being made by the advocate. I think they resent objections. I think that objections are perceived as a sign of weakness. I think that's not true of the rest of the case. I don't think jurors resent objections when evidence is being presented in the same way as they do when someone stops someone else from talking in closing argument. The second thing, second difference, I think, particularly when we talk about incentives, this is something, you know, are we going to incentivize defense counsel to object or what? This is something that is uniquely within the power of the prosecutor. If we really want to reduce the number of improper arguments, it makes sense to put the incentive on the one party that absolutely can control whether there is an improper argument. And the third thing, I said I was going to do two, I'll do three. The third thing is, this is an example of, yes, there is if Hawkins were abandoned, yes, there was a strategic decision for the defense counsel to be making. It's a very unfair one to put the burden on defense counsel, either do something in the moment of objecting, which you think is going to hurt your client, or don't do it and you hurt your client on appeal. And I think that's an unfair dilemma to put defense counsel in. I do want to talk a little bit about the facts of this case and the improper arguments that were made here, because I think that is important to understand. Obviously, we've cited a whole number of improper arguments. In talking about the ones that particularly were in the motion for new trial, I would categorize them sort of as three things. One, arguments that directly attacked the character of the defendant. So we had an argument where the prosecutor called the defendant a coward because he had not run away from police. There was a significant issue of the prosecutor going into this attack on Mr. Enix, not being a good father, not seeking a relationship with his other children. That was an argument that both had no factual basis in the record, but also even if it had even if it were established, that's irrelevant. Whether or not Mr. Enix was a good father, had a good relationship with his other children, never should have been part of whether Mr. Enix is guilty. The second sort of category of issues here really relate to the demonstration by the prosecutor right at the beginning of his argument. The record reflects that he banged on counsel table, counting out 1, 2, 3, all the way up to 47, then talked about how out of breath he was. There's no indication that that bore any particular relationship other than 47 or any particular relationship to the facts in this case. But what it was theatrics. What it was banging on a table in front of the jury to start the closing argument in a way that could only have heightened the emotion of the situation.
But Mr. Harwell, doesn't theatrics sometimes play into effective closing arguments? I mean, we have to expect some of that, don't we?
And this victim was stabbed 47 times, right?
The victim was stabbed 47 times. There's no proof, though, that it happened anything like the way that the prosecutor was doing it. And so, yes, certain amount of theatrics, I guess, we're used to, but this was, I think, theatrics for the sake of theatrics for the sake of getting the emotions of the jurors flowing. And the third category, I think, is the most harmful category. And I want to talk in a minute just about the holes in the state's case. But there was a hole in the state's case as to what happened immediately before and after the killing. And what the prosecutor did was he filled those holes. He filled them with speculation. So there's an argument that he made. There was a phone that was broken. And he suggested to the jury that what must have happened was that Mr. Enix wanted to get in that phone, had somehow gotten the password out of Ms. Enix, had gotten into the phone, had seen that she was having text messages of a romantic nature with another person, and that he had responded jealously and broken the phone. The prosecutor said, this is sort of the key to what happened here. And none of that do we have any idea if that's accurate or not. So we have speculation being offered as fact by the prosecutor, filling a hole in the state's case. And in particular, there's a danger the jury is going to think, yeah, we didn't hear any evidence that established that's why that phone was smashed. But that guy seems really sure of it, so he must know something we don't know.
Wouldn't you say, though, that could have been a reasonable inference from the proof? And if a prosecutor overstates the evidence, the jury could also decide, if I don't believe him on this point, if he misstates on this point, then he may be misstating facts on other points. Therefore, the prosecutor could lose credibility for the entire argument because of overstating something. So there's two sides to that.
I think there are two sides. I do not agree that is a reasonable inference from the fact that there's a phone that is broken. That is speculation and guessing, and that is not permissible in closing argument. So I do think it goes far beyond just drawing an inference. And isn't
that exactly the kind of conduct where if that's true, if there's no evidence of that, defense counsel would be very justified, and I would think the jury would not resent it if he said, I object, there's zero evidence of that. There's no evidence of that in the record. Why would defense counsel choose not to object to something that is as egregious as you are describing?
And I don't have the answer as to this specific case. I do think, as I've mentioned, there's a culture of not objecting. There is a fear that the objection is going to be viewed as antagonistic, as irritating, as a sign of weakness. And there's the expectation it's actually not going to accomplish much.
Well, Mr. Harwell, particularly in the situation that you're talking about there, where you're claiming that the prosecutor is simply putting evidence out there that wasn't actually at trial, isn't that a perfect opportunity for defense counsel to then stand up and say, look, prosecutor said X. Can you recall a single witness talking about that? Where is the proof in this record to do that? And thereby using that to very much destroy the prosecutor's closing argument.
I think that is a possibility, but I don't think that justifies the correctness of the argument in the first place.
All right, thank you, Mr. Harwell. Mr. Groves?
Good morning, Your Honors, and may it please the court. My name is Alan Groves, and I'm here on behalf of the state of Tennessee. This court should hold that plain error review applies to a claim of improper closing argument when the defendant fails to lodge a contemporaneous objection. Raising the issue in the motion for a new trial is not enough for 3 reasons. First, the rules of criminal and appellate procedure require contemporaneous objections, and they do not carve out an exception for claims of improper closing argument. Second, this court has held for more than 40 years that contemporaneous objections are required to properly preserve a claim of improper closing argument for plenary review. And third, contemporaneous objections give trial courts the opportunity to either prevent or immediately correct an error before it's too late. So this avoids the extreme remedy of granting a new trial, which prolongs uncertainty for the accused, delays closure for victims, and increases costs for everyone involved.
Rose, this is Justice Bivens. Doesn't Mr. Harwell have a point, though, that regardless of whether there was extensive analysis, Hawkins held that you should be entitled to plenary review of the matters that are raised in the motion for new trial, regardless of whether there was a contemporaneous objection or not?
Justice Bivens, Hawkins held that the state's allegedly improper closing arguments were either not improper or that they were harmless. The holding of Hawkins was not that there is a new rule, a new standard of review that the court is going to start applying in future cases when there was no contemporaneous objection.
But the court, in fact, did apply plenary review to those 2 issues.
Certainly, Your Honor. And the outcome of the case obviously would have come out the same way if it had applied plain error review, because if arguments are not improper under plenary review, then they're not going to constitute plain error either. So it wasn't necessary for the holding of the case necessarily. But as
this is Justice Page. Let me ask you about my question concerning the word rape that was the subject of a pretrial motion. Putting Hawkins and everything else aside, if we had a brand new case where there was a pretrial motion like that, but no contemporaneous objection, could the court still apply plenary review because it was brought up pretrial? I guess what I'm asking is defense counsel free to not object in that situation?
It depends on the circumstances, Your Honor. And that is how the Court of Criminal Appeals in this case distinguished Hawkins, by noting that one of the objections involved a pretrial ruling about the word rape. This court in State versus McGee, that's a 1988 case, the court held that sometimes making a pretrial objection, such as through a motion in limine, might be sufficient to preserve an issue for plenary appellate review, even in the absence of a contemporaneous objection. But in McGee, the court held that it's a very fact-specific inquiry. So it's not always going to be the case that making a pretrial objection is going to result in preservation of that issue. there might be circumstances where a contemporaneous objection is still required. And I think that's why the better explanation for understanding why Hawkins applied plenary review was that the state did not assert waiver. And first of all, I want to make it clear that even though in Hawkins, the court didn't specifically in that particular sentence where it said it was going to apply plenary review, it didn't say because the state did not assert waiver. But it's not entirely fair to say that the court wasn't aware and cognizant of the state's position. If you go back and review the opinion, right when the court is about to start this analysis of this particular issue, it summarizes the positions of the parties, like a lot of appellate court opinions do when they're starting a new issue. They say the defendant argues this, the state argues this. And in that introductory paragraph for the analysis, the court says the state is conceding that the use of the term rape was improper, but that it was harmless, and that all the other arguments were not improper, which is an acknowledgement that the state is defending all of these allegedly improper arguments on the merits under plenary review. So
Well,
it
Mr.
wasn't
Groves,
necessary.
this is Justice Page. We have another issue. The prosecutor mentioned the word rape, but he also talked about the fact that the prosecutor also called the defendant, said he's mean. That was the second issue included in the motion for new trial, and that was really never addressed in a pretrial motion. Are you saying that was just overlooked by the court in Hawkins?
Well, this court could clarify if the holding of Hawkins truly was because of the pretrial objection with the word rape, and perhaps the other comment was overlooked. But I think a reasonable explanation is that the state wasn't arguing that either one of those comments were waived. And so the court wasn't required to apply plain error review when the state wasn't asserting waiver. And we've cited many cases in our brief where appellate courts often will review an issue on the merits if one party is raising the issue affirmatively and the opposing party doesn't assert waiver. The plain error doctrine is discretionary in that sense. So the court wasn't necessarily required to review even the comment about the defendant being mean in Hawkins for plain error review. But as this court has noted this morning, when this court decides to overrule a case, let alone precedent lasting more than 40 years, it typically engages in a stare decisis type of analysis to decide whether those cases deserve to be overturned, whether there's a good enough reason. And in this case, the court didn't do any of that. And in fact, it favorably cited two cases, Thomas and Banks, which specifically state that contemporaneous objections are required in this context, and that failure to lodge them results in waiver of the issue on appeal. And even after Hawkins was decided, this court has continued to cite cases like Thomas or Jordan or the United States Supreme Court decision in Young, which states that plain error review applies when there's no contemporaneous objection. This court continues to cite all of those cases without the slightest indication that they've been partially overruled on this issue. And Justice Kirby, to one of your questions about what other jurisdictions do on this issue, the defendant didn't cite any cases from other jurisdictions. So I didn't do a 50-state survey, but I did try to look at some of the other states, and I wasn't able to find any cases that held the rule that the defendant is advocating here. Now, he does cite a couple of Sixth Circuit cases in his reply brief in a footnote. And I did look those up and did a little digging on how the Sixth Circuit handles this. And I think the defendant's misreading those cases. They do talk about how, first, I think under the Sixth Circuit analysis, you first ask whether the argument was improper. And then you ask whether the argument was flagrant or non-flagrant. And then if it's non-flagrant, the court does say you consider, did the defendant object and was a curative instruction given? But that's essentially the same exact analysis that the judge factors employ under plenary review in Tennessee. And the judge factors come into play when you're evaluating whether there's prejudice, whether the improper argument was harmless, even under plenary review. And even under that standard of review, the court does look to see whether curative measures were given, because that is a relevant consideration. But it's kind of presupposed that the defendant did object when you're operating under that plenary review analysis under judge. And I think that's exactly what the Sixth Circuit is doing. I found other cases, Gonzalez it's a 2008 case from the Sixth Circuit, which specifically says, if you don't lodge a contemporaneous objection, we only review it for plain error. So I just don't think there's authority for other jurisdictions applying the rule that the defendant is advocating here. Justice Lee, to your question about is death different and what about Hawkins being a capital case? This court has never held that there's a per se rule that the court will always review allegations of improper closing argument for plenary review in a capital case. And in fact, Hawkins itself applied plain error review to a couple of the claims. So I don't think this court has ever held that there's such a per se rule, and it shouldn't. The state's not asking the court to say that. And you really don't have to reach that issue in this case because neither Hawkins nor this case is a capital case. And if there are no further questions about Hawkins and the holding of that case in particular, I can turn to the policy reasons why this court should reaffirm the longstanding holding that contemporaneous objections are required. And first, it's already received a lot of discussion today, but I do want to emphasize it, that trial courts need to have the opportunity to prevent or correct errors in real time. And for instance, if a defense attorney objects to, let's say the prosecutor calls the defendant a name that he shouldn't have, or he's just really passionate about this particular case and starts making a couple of comments at the beginning of argument that are not really proper. If the defense counsel objects and the trial court steps in and admonishes the prosecutor, that could potentially change the tone of the entire rest of the argument, preventing further misconduct from occurring. And so it's very important that those objections are lodged in order to prevent further errors or to compound errors. If the prosecutor is using a particular word that maybe he shouldn't be using, if the defense counsel objects, he's going to stop using that if the trial court instructs him not to. Or if it's already too late, if the prosecutor has said something they're not supposed to, a curative jury instruction can be given, as Justice Page was mentioning before. And defense counsel's arguments that, well, maybe the jury either couldn't follow that instruction or would resent the defendant for making that objection, I don't think that those are persuasive for a couple of reasons. As Justice Kirby mentioned, we assume that juries follow the instructions of the trial court throughout the trial. This is not something that's unique to the closing argument context. So to say that the jury wouldn't necessarily follow the instruction that's given is not really unique to this context. And defense counsel is always welcome to step in and help the trial court fashion an appropriate instruction if he thinks that the standard, the statements of counsel are not evidence instruction is insufficient for some reason. But another issue that I just want to push back a little bit on is the assumption that juries are going to resent an objection. I don't necessarily think that we have proof of that, in the record. I think we're kind of speculating. And Justice Kirby, again, you kind of alluded to that. If the prosecutor is making an outlandish argument or asking the jury to draw an inference that's just in no way supported by the record, I don't know why we would assume jurors would resent the defense attorney for drawing that to the attention of the court and asking for an appropriate instruction. So I think some of those policy arguments that the defendant is making about how jurors would react beg the question a little bit and maybe assume things that aren't exactly true. We also have to think about what would be the implications of adopting the defendant's rule here. And it would definitely shift the burden to trial court judges to raise these objections on behalf of defense counsel. Because if the court doesn't, then there's a chance that he's going to raise some of these issues on appeal. Because what does it hurt to just throw it in your appellate brief if you don't waive the issue? And so the trial court has to run that risk. But then if the court intervenes sua sponte, then it runs the risk of the defense counsel saying, no, Your Honor, I was fine with that argument, or, I didn't want you to draw attention to that that improper argument or that inference the prosecutor was asking the jury to draw. I was hoping to just sweep that under the rug, or I was hoping to address that in my own closing argument. And this court in State versus Vance specifically held that we shouldn't put that much pressure on trial courts to intervene sua sponte when they're not really in the best position to evaluate the positions of the parties and what they desire and how they want to try their case. A second policy argument that we've identified in our brief is that contemporaneous objections give trial courts the ability to make further factual findings, which are often very useful to the appellate courts in reviewing issues. And especially in closing arguments, if the defense counsel's arguing that a certain argument was improperly inflammatory and it was appealing to the passions of the jury. If the trial court's given an opportunity to make findings, it could say, yeah, I saw juror number 12 crying hysterically as soon as the prosecutor started doing X, Y, or Z. Or, juror number 11 was, extremely distraught and seemed disturbed by this. But if there's no objection, the court's not given opportunities to kind of develop the record in that sense, then the appellate court's kind of hamstrung in its ability.
Can't that be done in the context of a motion for a new trial? I mean, that happens fairly soon after the trial is over with. The trial judge is going to remember. So what, as to that, the trial judge has plenty of opportunity, doesn't he, in the context of a motion for new trial to complete the record with his own personal observations that may not appear in the transcript.
Sometimes, Your Honor, the trial court does make additional factual findings at the motion for new trial stage. It does happen a little bit later, and if the court was never alerted to the issue in the midst of trial, it might not have been paying as attention to certain things because it wasn't being asked to. So the court's finding, it's still in the best position to make those findings at the motion for new trial stage, but it's a little bit at a disadvantage when the issue was never raised in the trial court. But I just want to double down a little bit on defense counsel's assertion that, well, as long as the trial court has the opportunity at the motion for new trial stage to address all these issues, then that's just sufficient. But that's simply not the case, because as the court held in State versus Minor, the purpose of the contemporaneous objection requirement is to prevent errors from happening. So we're not in a situation where we're looking at a motion for a new trial and making all the parties redo it all over again. Because at the motion for new trial stage, yes, the court has the opportunity to rule on the issue, but it's left with a binary choice. It has to either grant a new trial and again, make this litigation just start over from scratch, or it has to say, nope, too late. But that binary choice isn't the same type of decision that the court has in the midst of trial, when it can give appropriate jury instructions and it can respond to the situation in real time with input from the parties. And so lastly, I want to address the defendant's policy arguments that in closing arguments, contemporaneous objections are just too burdensome and that we should create a new exception. One of his arguments is that closing arguments are just too fast paced to keep up, and that defense counsel can't be expected to think about what the prosecutor is saying that might be improper, because you might not know what the prosecutor is going to be saying. Whereas in the proof, you have kind of a question and answer format. But to that, it's not exactly true, because even in the proof stage of the trial, defense counsel also has to be thinking about, how is the witness responding to the questions in a way that maybe they weren't being asked, maybe they're just volunteering information. You still have to be ready to object at a moment's notice, even earlier in the trial. So the fact that it's fast paced is not exactly a distinguishing feature. And the defense counsel also has to be thinking during the proof about how to respond during his cross-examination by asking new questions that are going to undermine the state's theory of the case, or that are going to get at weaknesses in a witness's responses. So the defendant's arguments that closing arguments are somehow unique is just not persuasive. He really relies most heavily on this idea that our legal culture in Tennessee just prioritizes civility and respect. But here again, he's ignoring available alternatives for making objections that might not even raise the issue to the jury's attention at all. Most notably, he could ask for a bench conference during closing arguments to have that discussion outside the jury's presence. And in United States versus Young, the US Supreme Court specifically said that's a very good way to raise these types of concerns. If you're not wanting to draw attention to a potentially prejudicial error during closing argument. If the court has no further questions on these policy matters, I will address the arguments at issue in this case. As we mentioned in our brief, this court only granted permission for the defendant to appeal on this narrow issue of what is the appropriate standard of review when a defendant doesn't raise a contemporaneous objection, but then raises the issue in the motion for a new trial. In this case, there's only 4 closing argument issues that really fall under that umbrella. And so we think the court should really disregard all of these other allegedly improper arguments that don't meet that specific standard, that fall within the scope of the court's Rule 11 grant, because there's no dispute that one of the issues was properly preserved for plenary review, and all the other ones were waived for plain error because they were raised for the first time on appeal. So we would urge this court to just disregard those other arguments and to focus on these 4 that are that fall within the scope of the Rule 11 grant. And the first of those 4 is the physical demonstration. And as your honors have mentioned, this was a very appropriate way for the prosecutor to emphasize to the jury intent and premeditation. And under plain error review, the record doesn't even clearly demonstrate, what exactly happened. We know he was pounding on the table for some of these during this counting exercise. We don't know how many times, how loudly he was pounding, what the jury's reaction was. So for that reason alone, it would not be appropriate to grant plain error relief, but it also didn't breach a clear and unequivocal rule of law. And the proof of guilt in this case was pretty overwhelming. And that factor is going to go towards all of these 4 claims. The jury heard proof that the defendant told the victim he was going to put her in a body bag if she left him, which she did. The jury heard proof that the defendant told the victim he was going to break her neck if she allowed him or allowed their daughter around other men, which she did. The jury saw plenty of proof about the text messages between the two and the defendant's increasing jealousy and manipulative behavior in the weeks and days leading up to this murder. So the proof of premeditation was pretty overwhelming here. And that alone shows that none of these claims were so exceptionally flagrant, as the court said in Banks, that it would require plain error relief because it adversely affected the defendant's right to a fair trial. Some of the other arguments about the victim's iPhone and his flight to Canada, these were arguments that were based on the proof, and the prosecutor was asking the jury to draw reasonable inferences. And whether those inferences were strong or weak is not really the point. As Justice Lee mentioned, the jury was free to either accept those inferences and to draw them or to disregard them. So there was no breach of a clear and unequivocal rule of law with respect to those claims. Finally, the 4th claim is the defendant or the prosecutor calling the defendant a coward when he didn't run from police in Ohio. I'm not sure why the prosecutor used that word. Name calling is generally inappropriate. I think from the context, the prosecutor was kind of confused about the defendant arguing that not running from the police disproved that he acted with premeditation when he'd already fled across 3 different states. And so, irrespective of whether that word was proper or not, it wasn't one of these exceptional circumstances where an isolated use of one word is going to affect the fundamental fairness of this entire trial. So for all those reasons, we submit that the 4 claims that properly fall within the scope of this court's review do not rise to the level of plain error relief. And I'd be happy to address the other improper arguments that the defendant asserts in his brief. I believe there's 7 more, but unless the court has further questions about those, We would respectfully ask the court to affirm the judgment of the Court of Criminal Appeals.
Thank you, Mr. Groves. Mr. Harwell.
I have a few points. The most important point I would like to address the claim that this evidence was so overwhelming that none of this mattered. And I think there was very strong evidence, obviously, that Mr. Enix committed this killing. There was very strong evidence that there was a very troubled relationship between the two of these two people. There's evidence, as Mr. Groves mentions, evidence of arguments in the past. There was evidence that Ms. Enix had assaulted Mr. Enix, and Ms. Enix had assaulted another ex-husband. So a troubled relationship. But then on the issue of what actually happened the night that the killing occurred, the state really didn't have any evidence. There's just this big hole of he went to her house and by the next day she is dead. What happened? Was there an argument before? Was there a fight? What led up to the stabbing? There was a hole. And that hole mattered because one of the things the state had to prove, really the main thing that the defense raised, was the state had to prove that this sort of over-the-top killing with all of these stab wounds followed by this sort of failure to clean up the scene in any meaningful way and a kind of half-hearted fleeing the jurisdiction. The state had to prove that that killing was premeditated in the sense that it occurred when Mr. Enix was sufficiently free from excitement and passion so as to be capable of premeditation. And if the state didn't have proof as to how the killing actually happened, there certainly was a jury issue as to whether or not it had proven beyond a reasonable doubt that he was sufficiently free from excitement and passion. So yes, there's clear evidence of 47 stab wounds, clear evidence this is a bad crime. But whether or not the state had proven the absence of excitement and passion was very much a jury question. The other thing I would say as to whether these arguments mattered or whether the evidence was so overwhelming that obviously the jury is going to convict regardless, we have one at least piece of circumstantial evidence, and that's what the prosecutor did. It's an experienced prosecutor. He thought these arguments mattered. He's not making these arguments just to amuse himself. He made these arguments because he thought that was the best way to convince the jury to find Mr. Enix guilty. The two more points I'd like to make, and this is maybe reiterating something I said before. The state claims that the rule I'm suggesting, the rule that Hawkins held, is misguided and that it puts a burden on the judge to control things. I think that's not what's happening. The Hawkins rule puts a burden on the prosecutor. And again, in a practical perspective, that is something that needs to happen because we have a problem. And I say that not for you to take my word for it, but for you to take Judge Woodall's word for it in 2018. And he wrote, "It seems almost amazing that statewide improper closing arguments continue to be made over and over again. We have a problem. Let's put the incentive to stop the problem on the people who are causing the problem." And the final thing I will say, and this goes to what was the holding of Hawkins and what is this court going to do now, is Hawkins was decided in 2017. It's our argument, and I think the record of that decision reflects, for whatever reason, in reaching the decision, the court found that the court reasoned that inclusion in the motion for new trial established a right to plenary review. That is part of the holding because that is the analytical path that the court followed to reach its final decision. That was issued in 2017. Mr. Enix went to trial after Hawkins. So I think it would, even if this court decides that Hawkins should be overruled for future purposes, I think it'd be unfair to Mr. Enix to impose that new rule on his claims, which were made at a time that Hawkins was good law. And if there are no further questions, we would rest on our briefs and ask this case be remanded for a new trial.
Thank you, counsel, for your arguments. That concludes the morning session for our docket. We will be in recess until 1 o'clock Eastern time. We have a case at 1 and another one at 2:30 this afternoon. So we're in recess.
This honorable court is now in recess.